Similarly, before the members leave the court, the orderly will say, "All rise," and everyone will rise. The members will bow, you will bow, and remain standing until the members leave the court. If you arrive at court after the court has started, you must enter quietly and bow towards the members and then take your seat. If you need to step outside at any point, rise quietly, face the members, bow, and leave quietly. Listen for your matter being called, as yours may not be the first to be heard. When your matter is called, you should stand to acknowledge your presence. The presiding member will ask for the appearances, which means who is representing each side in court. When it is your turn to speak, if you are not represented by a lawyer on that day, you should indicate this to the court. If you arrive in the courtroom after the members, you can ask the police officer or bailiff quietly whether your matter has already been called, so they can assist in bringing your presence to the attention of the court if necessary. In the courtroom, attorneys are allowed to sit at the bar table and all other persons sit in the public gallery. When speaking, you must speak directly to the presiding member or any of the other members who has spoken to you. When addressing a member, refer to him or her as Your Honor, and to more than one member as Your Honors. Speak clearly and not too quickly, because notes of what you say must be taken by the court. Do not speak when a member of the court or one of the other parties is speaking. Do not argue with the other party or their lawyer. Do not use vulgar or abusive language. Be wary of your body language. Do not stoops, roll your eyes, or make faces at the other side or anyone else during court proceedings. Remember, you want to present yourself and your case in the best possible light. Make sure you have the original document and enough copies for the other parties to the proceedings. If there are 3 members hearing your matter, you need to bring 3 additional copies for them. You should have a notepad to take notes of what happens, especially of adjourned dates and what is supposed to happen on those dates. Take note of anything you or the other parties are supposed to do before that date or otherwise. You must comply with all instructions or rulings or orders of the members of the court. Failure to do so may be regarded as contempt of court and could have serious consequences. You should pay attention to the terms which will either be in the documents served on you or which you will hear the presiding member say when adjourning court. The first time a matter is heard before the court will often be a preliminary hearing. At the preliminary hearing is where the court will get a sense of the possibilities of early resolution and whether it is appropriate for mediation. At the preliminary hearing, the court can give directions as to what the parties are to do next. A preliminary hearing is usually before only one member of the court. When a matter is listed for mention or adjourned for mention, then on that day, the parties will come to court to report on the status of the matter. A matter may be adjourned for mention when the court has referred the parties to mediation or has given the parties time to take some action. When an application is listed or adjourned for hearing, or an appeal is listed or adjourned for trial, then on that day, the full panel will hear the arguments and the evidence of all the parties in the matter. When an application is listed or adjourned for delivery of ruling, or an appeal is listed or adjourned for delivery of judgment, then on that day, the court will make its decision in the matter known to the parties. The court is mandated by the Environmental Management Act to encourage and promote alternative dispute resolution as a means to resolve issues arising between the parties. This means that at any stage of the proceedings, the court can allow the parties to try to find a solution to some or all of the issues by negotiating between themselves or by mediation. Mediation involves an impartial third party controlling discussions between the parties to arrive at a mutually acceptable solution. If the parties come to a solution, their agreement can be made into an order of the court if it is acceptable to the court. The final decision on this lies within the court, which will ensure that any proposed order is within the law. Another way for parties who have arrived at an agreement to dispose of the matter is for the matter to be withdrawn by the party who commenced it. After members have heard all of the evidence and arguments in the matter, they will come to a decision. This may not be on the same day the matter was determined, and the court will let you know when the decision of the court will be delivered. The final outcome of the matter will be recorded in a written order of the court, signed by the registrar, and a copy of this will be served on all the parties to the proceedings. You must comply with any final judgment or order of the court. Failure to do so may be regarded as contempt and result in serious consequences. You should remember the following guidelines. Be on time for court. Dress appropriately. Be prepared to present your case. Do not disrupt the court. Address the members of the court as Your Honor. Pay attention to timelines or deadlines for things you are required to do in relation to your matter. Take proper notes of everything you and the other parties are supposed to do. Be sure to comply with the instructions of the court. It is always advisable to seek the advice of a lawyer where possible. If you follow these guidelines, you will be better prepared to present your case, and the Commission will be better able to deal with your matter efficiently, expeditiously, and fairly. For more information, please feel free to contact or visit the Registry of the Environmental Commission or the Commission's website.